Welcome back to Good Law, Bad Law. On this episode, my guest is Rob Mikos. He is a law professor at Vanderbilt Law School and the author of the nation's first textbook on marijuana law and policy. Well, we just had to talk to Professor Mikos about where we stand in this country regarding marijuana law, and it turns out that not only are more and more states turning to legalizing marijuana for medical use and even for recreational use, and more states are going to follow in the years to come, but this issue is touching every aspect of our economic and social life, from banking to employment. What is a company that employs people in a state where marijuana is now legalized? How do you deal with that as an employer? There are so many questions to understand the answers to here, and Rob is a leading authority and a great scholar on the subject. I know you'll find this episode, as we explore marijuana law and the implications for our states and for the federal government in this episode, I know you'll enjoy. Thanks, and stay tuned. Welcome back to Good Law, Bad Law. My guest today on the program is Robert Mikos. Rob is a law professor at Vanderbilt Law School and has the first ever textbook he's written and had published on marijuana law and policy. So we have just the person to have walk us through where we are in this country today in terms of marijuana law in the various states and the tension with the federal government. We're going to talk about all that today with Robert Mikos. Rob, thanks so much for being on the program.
Thanks, Aaron, for having me.
I have to say, this is really an extraordinary statement about how far we've come in this country, that in a major American law school, we have an individual, yourself, who not only teaches marijuana law, but has actually written and had published the first textbook on this area of the law. So that's, first of all, congratulations. That's really something. And maybe, is that as a jumping off point, you could give us a little background on yourself and how you came to this subject and came to become the authority on it that you are today.
Sure. I had no intention when I started as a law professor. I had no intention or even any expectation that I'd ever be teaching in or writing about marijuana law. Had no passion for the subject, no familiarity with it when I got started more than a decade ago. But I was actually teaching out at the University of California, Davis. That's where I had my first teaching job. And there was a big federalism case coming up before the Supreme Court. And I started out as a federalism scholar. The case was Gonzalez versus Raich. Ostensibly, it dealt with sort of the outer limits of Congress's interstate commerce power. But it happened to be applied to the issue of medical marijuana. It was all about whether Congress could ban the intrastate cultivation and distribution of marijuana, even though the state was allowing that. So I was interested in that case.
Yeah, Rob, just before, I want to make sure people understand what federalism means as you're using the term here.
Yeah, federalism is all about the relationship between state governments and the national government, the federal government. So that's what we mean by federalism broadly. What sort of things can the federal government do? Are there any areas of law that are off limits to the federal government? How do we reconcile when both the states and the federal government try to regulate a subject? How do we try to reconcile their laws? So that's really what I mean by federalism broadly understood.
Gotcha.
So I was interested in federalism, interested in this case. The case came down. It upheld this federal ban on marijuana, even as applied to activities that took place entirely within a state. You had a dissent from then Justice Sandra Day O'Connor saying this would put an end to California's medical marijuana law. California was a pioneer in this area. California decided to legalize marijuana for medical purposes. in conflict with federal law. But what was interesting to me being out in California is I saw that the case didn't change anything on the ground. You still had at the time these medical marijuana dispensaries operating out in the open. You saw more and more of them operating out in the open. I thought this is an interesting situation here. We have a federal law that bans this activity, a state law that allows it, and the federal ban doesn't seem to have much traction, doesn't seem to be having much effect. So I thought I'd be done with it at that point. I thought I'd study this case and try to figure out why there was this disconnect between the court's ruling and the effects on the ground. And then I started digging into these medical marijuana laws at the time and discovered that they raised all sorts of fascinating questions about federalism. Exactly what can the state get away with? Can it legalize a drug the federal government forbids? Can it regulate the drug? Could you even have state-operated stores, for example? Raises all sorts of separation of powers issues, like could the president unilaterally legalize marijuana without a new statute from Congress? Raised all sorts of other substantive issues that were of interest to lots of different parties, like can lawyers practice? Can they provide advice to marijuana licensees without flouting the model rules of professional conduct? Wow. So I started digging into those issues, and I discovered over time, even though I moved from very liberal California out here to a very red state, Nashville, which is in Tennessee, here in Vanderbilt, I stayed interested in these issues and discovered that there are lots of people out there who really need legal advice in this field, and so I proposed a textbook. Thought law schools should be offering this subject. Proposed a textbook, and fortunately, not just had a big law school, a major law school, support me in this, and my deans and my colleagues support me in this, but it's a law school in the Deep South. And I had a leading law school publisher, Aspen, which is owned by Wolters Kluwer, a big law school publisher, jump at the chance to publish this book. And it took several years to actually write it. It was a much more difficult topic than I even imagined at the start. But it came out last year, and I think it's been pioneering. I think it's made it much easier for other people to offer the course, and really has opened the door in law schools for a lot more of them to offer courses in this area.
Well, and it's fascinating that you might imagine that a course on marijuana law would be kind of a fringe course, and as you're explaining, it really isn't, and brings into play so many issues that go beyond the subject of marijuana, that whether it's constitutional law and the issues of federalism, criminal law, tax law, business law, all these different issues played out through the lens of marijuana. But similarly, this, you were in California 10 years ago, but in the last decade, we moved from a time when this was something primarily that was being pioneered by California to a point, and I had to look this up this morning just to double check the numbers, but there are now 31 states, along with the District of Columbia, Guam, and Puerto Rico, who have legalized marijuana for medical use, and there are 9 states now who have legalized marijuana for recreational use: Alaska, California, Colorado, Maine, Massachusetts, Nevada, Oregon, Vermont, Washington, and the District of Columbia. So this is far from a fringe subject. This is now mainstream, and just seems more and more like a big wave that is sweeping over the country.
It has. It's geographically speaking, I think you've gotten the numbers right. It's hard to keep track, given that there's so much movement in this area. But in addition to those 31 states plus DC that have medical marijuana laws, and that includes those 9 states plus DC that have the recreational, really every state but Idaho at this point has legalized some drug that the federal government considers to be marijuana. for medical purposes. Those other 18 states that are not included in the medical states, they've legalized CBD, which is a non-psychoactive chemical, a cannabinoid found in the cannabis plant for certain medical purposes. So it's really spread geographically farther than most people recognize, and those medical reforms have started to permeate even into more conservative parts of the country. Oklahoma, Arkansas, North Dakota, Florida have all adopted them. Utah is on the fringe of adopting a full-blown medical marijuana law. So it's really remarkable how far these reforms have come in the course of about 2 decades. California started this back in 1996 with its Proposition 215, its medical marijuana law. But it's remarkable just how far these reforms have come.
Well, and I want to get into some of the issues that you can project for us. We're going to be facing in say the next decade, as both the business and the law and the politics really of marijuana continue to advance in our country. But I want to pause for a minute and try and understand this incredible change that has come all across the country. And recently, Canada announced that it was legalizing marijuana, I think, for all uses there. So we're seeing not only change within our country, but change that's going to affect the citizens of this country by actions that are taken in other countries too. So, how do you, looking back, explain all of this? Is it that the medical uses of marijuana really kickstarted this and drove this wave of change that's come about? Is that what you see when you look back?
Yes, I think we've seen a shift since then, but I think it all started with the claim that marijuana might have some medical benefits for people suffering from certain serious medical illnesses. And that was a very sympathetic claim to make. And I think the public was willing back in the 1990s to look at that and say, all right, we can legalize this drug, which might otherwise be bad, but we can legalize it for some people who might actually benefit from it. So it's not it's maybe a controversial claim to make scientifically, but politically speaking, those initial medical marijuana laws were built on or fueled by the notion that marijuana can have some medical benefits to people who are suffering otherwise. And I think once states like California adopted those laws and other states came on board as well, and they demonstrated that, well, if you do this, if you allow some people to have access to medical marijuana and the sky doesn't fall,
Right.
It didn't fall in any of those states,
Right.
I think people start to become more comfortable with this notion that maybe we could relax the laws regarding marijuana. And then around 2010, and really it wasn't until 2012 that we got these broader recreational or adult use laws. I think the sales pitch started to change at that point. So people were more and more comfortable with medical marijuana laws, but then to convince people to approve of broader recreational laws, the sales pitch became more about tax revenues and about jobs, and less about sort of the medical benefits, right? So proponents would say, hey, rather than letting black market dealers make all the money from this, why don't we legalize it? We can create a licensed and controlled industry to help deal with the harms of the drug, but then we can take a cut of the revenues by taxing it and collecting licensing fees. And so it became much more an economic push. I think that was partly due to the timing as well. We were still going through the effects of the financial crisis. States were running short of tax revenues. And so this shift from benefiting seriously ill citizens to sort of benefiting the state financially and creating new jobs really worked, and that's what's been driving recreational marijuana laws since 2012.
How much, Rob, do you think the a growing appreciation for the impact of criminalizing marijuana possession in particular has had on the changes that we've seen and the evolution we've seen over the last 15, 20 years? Because we all, a big, huge part of our country bought into the 1980s war on drugs, just say no. But I think that may have been without fully appreciating what the impact of that was going to be, filling up our jails and prisons in a way that uh, makes us number one, I think, in the world, and something we don't want to be number one in. And so, there have simultaneously been moves to decriminalize, and I think maybe you need to explain what that means, because there is a difference between legalizing and decriminalizing. And how do you think that has been a factor as states have dealt with this? We talked about the medical aspect, we talked about the business aspect of this, but how much do you think that the decriminalization move has been a factor as well?
Yeah, so decriminalization, that means, taking some activity like possession of marijuana that at one point was criminalized, that carried criminal sanctions if you engaged in it, and making it a civil offense, but it's still illegal. So when you decriminalize, say, marijuana possession, you're making it more like a traffic ticket that you might get for speeding. If you go 10 miles an hour over the speed limit, you're doing something that's illegal, but it's not criminal under state law, and you typically get a fine. So some states, before they legalized marijuana, they decriminalized it or decriminalized some of the activities concerning it by taking away those criminal penalties and sort of downgrading the offense. The states, when we talk about these states that have legalized marijuana, they've done something more audacious. They say, hey, it's not illegal to possess, grow, or distribute marijuana. We're not going to fine you for it, civilly or otherwise. What you're doing is perfectly legal as long as you stay within sort of the limits imposed by the law. So it's important to recognize that there's a difference between decriminalization and legalization. Now, your premise or the first point that you were making about trying to undo some of this damage from the war on drugs, or maybe looking at marijuana prohibition, especially the criminal prohibitions, and seeing all the costs that those prohibitions imposed on society.
Right.
For a time, there were almost 1 million arrests annually across the United States at the state and federal level involving marijuana crimes. So that is every year, almost 1 million arrests involved some marijuana offense. That's more than probably any other offense out there other than maybe simple battery or domestic violence. So it was a very big chunk of the criminal law docket. And one of the arguments that's been given for legalization is a social justice argument. It's saying that these prohibitions were overbroad, that they were too harsh, that they were unfair, and we should not criminalize behavior that is relatively harmless, or if it does any harm, is likely just to harm the person who's engaging in it. So I think that was an argument out there, but it was not driving these reforms. I think most people tend to believe, hey, I'm not going to be arrested for marijuana, so what do I care if it's prohibited or not? I think these were these sort of arguments were appealing to a certain set of society that may be more concerned about social justice. But again, I think that the main thing driving these reforms is really we're creating jobs, we're creating tax revenues.
Right. Well, I mean, but 1 million arrests is, does impose a huge cost, not only on the dockets in the court, but then you have police resources and taking people out of their communities, and the cost of running jails filled with people convicted of marijuana crime. I mean, there's a lot of ways that imposes a huge cost. And in all of these arenas, as you said earlier, you have to have some state or a few states who are brave or audacious enough to take these steps. And then you have to see that, as you pointed out, the sky didn't fall. People aren't running around committing, violent crimes because of reefer madness, as the old film warned us would be the case. So there's just a matter of time and getting used to these things as well, I would think. That's a big part of it. But go ahead.
Oh, and the one of the aspects of those million arrests, one of the troubling aspects was that many of those were borne by minority communities, African Americans in particular. There was a much higher arrest rate for marijuana offenses, as for other drug offenses, for African Americans compared to whites and so on. Again, I think that provides a good principled argument for legalization, but it's an argument that probably a certain subset of the population cares about more than others. Communities of color, for example, are going to care more about that perhaps than upper class white communities. That's why I think it hasn't played a huge role in these debates, although it is another argument that can be made for reform.
Mm-hmm. Well, and then we have to deal with the challenges that have been faced by states moving in these directions, whether first to decriminalize, then to legalize for medical use, then to legalize for all uses, set against a federal law. And I think the law you're talking about is the Controlled Substances Act. Is that right? The federal law
That's correct. So the Controlled Substances Act, which has been on the books at the federal level, was passed back in 1970. From 1970 until today, it's really been unchanged. It bans outright the possession, manufacture, and distribution of marijuana, really making no exception for any medical or any other type of purpose. So all the while, when states have been engaging in these broader and broader and bolder reforms, we've had this federal ban on the books. And that's created a lot of tension, obviously, between state and federal law. And it's created a lot of headaches for states and for the people they're trying to regulate. Even up until today, when we've got the federal government taking a more relaxed stand on enforcement of that ban. So when California first adopted its medical marijuana law, this is during the Clinton administration back in 1996, it was interesting that a Democratic president took a very hard stand on California's law, basically called upon all federal agencies to consider what they might do to help crack down on this drug. So at that time, there was a lot of hostility between the federal government and the states, even though the gap between state and federal law was not as broad as it is today, because it really was all about, at the time, medical use of the drug. Since that time, the federal government under the Bush administration and then the Obama administration in particular softened its stand on marijuana. It didn't change federal law, it didn't change the scheduling of marijuana, didn't change the content of federal law. But you started to see, especially during the Obama administration, the Department of Justice suggesting that it wouldn't prosecute people if they were acting in compliance with state law, that it would defer to the states and respect the choices that they had made with respect to this particular drug. And even though the Trump administration and the new Attorney General, Jeff Sessions, rescinded some of that guidance that had been issued by the Obama administration, there still hasn't been a federal crackdown on all of these businesses that are operating with a state license. So I think we've got federal tolerance at this point, although even if the D.O.J. is sort of sitting by the wayside, isn't prosecuting or initiating cases against the industry, there are still a lot of problems that are created by the federal ban on marijuana that companies in this industry still have to deal with.
Yeah,
One,
it seems like part of the tension, and this is theoretical tension because the Controlled Substances Act, which lists marijuana in the same category as the hardest drugs that have been declared illegal in this country, because they haven't changed that law at any moment, and I think a lot of people worried about this when President Trump was elected and Sessions became Attorney General, that at any moment enforcement priorities could change, and you have a law that allows for federal enforcement of that law, and they could start, I don't know, raiding facilities, confiscating funds from these enterprises. I mean, arresting individuals, arresting lawyers. I've talked to lawyers who practice in this area who said, I don't know if under this current administration I could find myself in jail just because of being a lawyer who represents companies in this area. So that is that tension. Is there any sign that you're seeing that this theoretical tension could become more real under the current administration? And if not, why do you think that is? Why do you think they're sitting back in the same way that Obama and George W. sat back?
well, I think it all goes back to that Gonzalez versus Raich case that I talked about at the outset. The case that got me interested in this area in the first instance. Part of what I discovered at the time, that the reason why California was able to continue to roll out its medical marijuana law, other states jumped on the bandwagon as well, is that even though the federal government has these expansive constitutional powers, including the power under Supreme Court precedent to regulate even the cultivation and distribution of marijuana that takes place entirely within a state, its resources to enforce that ban are really limited.
Mm-hmm.
That's really where it comes down to. That helps explain a lot of the state's successes in rolling out these reforms. So you've got a federal ban on the books. The DOJ has all sorts of weapons at its disposal, criminal prosecutions, civil forfeiture actions, and so on. And yet the DOJ just doesn't have enough manpower to go out there and start arresting people.
Well,
even though it would.
Couldn't they pick one state, let's say, or even one city, and start going after banks and businesses and dispensaries and some of the larger targets within one area, just to send a signal? And they're not even.
You could try to send a signal, so to speak, and that's oftentimes what people worried about is I don't want to be made an example of.
Right.
But the problem even with that, imagine you've got the federal DEA, the Drug Enforcement Agency, that's responsible for marijuana as well as all other illicit substances, heroin, LSD, meth, and so on, as well as all legal prescription medications. So oxycodone, everything that you get at a pharmacy.
Yeah.
And you've got 5,000 law enforcement agents working with the DEA worldwide. They're responsible for all of those drugs. You've got more than that number of licensed marijuana shops in the country right now, sprinkled across those 32 states, or 31 states in the District of Columbia. So that's a lot of targets for the DEA to pursue. Now, sure, they could go after a handful of these and say, hey, we're making an example of them. But I think, if they go after 10 of those, the other 4,990 would probably say, well, I'm off the hook. You're going after them. You're going to be spending the next 5 or 6 years trying to prosecute them, initiate civil forfeiture actions. So that means you're not going to have the time to go after me. And I think that's really what's going on here. You have so many targets, so many users, and certainly so many growers and retailers out there that it would be hard to get a big enough slice of them to actually make an effective example. Yeah. Because there are so many historically who have been willing to flout federal law and take on these legal risks, so many more who would be willing to step in if some were sort of taken off the board. And you've also got to recognize that criminal prosecutions and these other legal actions that the DOJ could take, they take a long time to actually succeed and to actually conclude. And if you're a marijuana dispensary that happens to be targeted by the Sessions-led DOJ, what you might do is just try to delay the proceedings as long as possible until you get a change in Congress that's more sympathetic with you, or you get a new presidential administration that would simply drop the case.
Right.
And I think at this stage, that wouldn't be waiting for terribly long. In fact, with medical marijuana, Congress has already barred the DOJ from conducting any criminal prosecutions of the medical marijuana industry throughout the land. If the Sessions DOJ were to target a handful of recreational marijuana companies, even in just a few states, I think Congress would probably step in at that point and cut off funding for those. It wouldn't legalize the drug. You'd still be subject to some other legal hassles, but it would prevent the DOJ from really cracking down on this. So I think it's that lack of resources and the fact that the political will has changed in Congress, the political will to back up the DOJ. I think that's why we don't have to worry much right now about, at least about the DOJ cracking down on this industry.
And I would imagine too, the more states that move in the direction that California started us in and develop a statewide economy that is, a statewide marijuana economy, and have therefore a really more and more deeply entrenched interest in this, the more likely it is that if any action was taken by a president or a Justice Department, the more likely it is Congress would step in to expand those protections.
Yes, certainly at this point, we have more than a majority of states that have medical marijuana laws on the books. And that may be why we have these, they're called spending riders, that forbid the DOJ from using any budgeted funds against the medical marijuana industry. But certainly we've got 9 states plus the District of Columbia with recreational marijuana laws. Those include some red states as well as blue states. You've got Alaska, for example, that has a recreational marijuana law. The more states that jump on the bandwagon, and there are likely to be more this fall and certainly next year, the more likely Congress is to take away power from the DOJ if the DOJ decides to use it.
Do you have a sense, is this something you track, which are the next states likely to join those 9 in legalizing recreational marijuana? Is that something you have a finger on?
Yeah, so it follows an interesting pattern. So to date, Vermont is the only of those 9 states, the only one of those 9 states that has legalized recreational marijuana through a statute, a simple statute passed by the legislature. All the other 8, plus the District of Columbia, did so through a ballot referenda. Okay. So I think it's much more likely that we'll see recreational marijuana spread first in states that have easy access to ballot referenda. That was certainly true of medical marijuana laws. The first states to adopt those were almost all states that had easy access to ballot referenda. It's going to take longer in other states that don't have a ballot referenda. Places like New York, for example, where they've got a medical marijuana law. The governor is very interested, though, in passing this, but it may take a little bit more time in New York or other places to pass it through a statute, because state legislators tend to be more conservative than the population at large. You've got a majority of the country, close to 60% at this point, that would support legalization for recreational use, and majorities, across most states as well, not just nationally. And yet, at the state legislature, you are going to see a lot more trepidation and a lot more leeriness of this. State legislatures would much rather have the voters handle this so they don't have to be bothered with it.
Interesting.
So I think we'll see it first in those states like Michigan, for example, this fall. But we may see it as well in states like New Jersey next year through a state legislature, because you have in some pockets of the country, in some states, you do have state leaders who are very much in favor of legalization. But I would look first at those states that have easy access to the ballot initiative. I think those are the places where it will come first, and then it'll follow in other states.
Right. Well, now you've mentioned a couple of times as we've been talking, Rob, something I want to follow up on with you, which is this idea of states conducting marijuana business within that state. You mentioned that in the case that came up that first got you interested in this, in the Gonzalez case, and I'm imagining that this has some relevance to this tension between the federal law that criminalizes marijuana and all these states that are now expanding their economies in this area. I remember when I was in Colorado a few years ago, which was right around the time Colorado was legalizing for all uses, a lot of discussion about what. Okay, so you're a business and now you're selling marijuana. What do you do with the money? You know, what bank do you deposit those funds in? How do you transact business only within a state and avoid interacting commercially with a state that may not have legalized marijuana in the same way, or interact with the federal banking system that obviously doesn't recognize marijuana legally in the same way? Where are we in those areas, and how important is that limitation that states operate within their own state boundaries? How important still is that idea?
Well, I think it's still an important practical idea for sort of federal enforcement policy. So historically, when the states have legalized this drug and they've legalized the possession and manufacture and distribution, their laws only cover possession, manufacture, and distribution within the state. They don't allow people to take it outside the state. They don't allow people to bring it back into the state, to import it or sell it from elsewhere. And partly that was based on concerns about how the federal government would respond. So even though you had Gonzalez versus Raich saying, hey, the federal government could, if it wanted to, prosecute someone in your state, even if they never left the state, even if they did no interstate commerce, they can go ahead and prosecute them. I think a lot of states realize that the Department of Justice tends to prioritize activities that cross state boundaries. Right. So if you had Colorado openly selling the drug to people who lived in Nebraska and elsewhere, shipping it out to those states, I think you would have been much more likely to see the DOJ step in and crack down. So I think states have volunteered to try to keep this drug within their own borders. They haven't been entirely successful at that, and because of the tax revenue they generate from out-of-state customers, they can welcome sort of marijuana tourism. But at least on the surface, they're trying to keep this within the state, less because of the legal reasons, less because that's constitutionally significant, and more because they believe that's less likely to trigger a response or a crackdown from the DOJ. But there are still problems this industry faces because you have an industry that maybe it's being left alone by the federal DOJ. It's generating a lot of money and it's generating a lot of cash. And what do you do with that money? Well, right. Normally, if you're a business, you take it to the bank, you deposit in the bank, you pay your employees with checks drawn on a bank account. You draw a loan from the bank, maybe a line of credit from the bank. That's very tough to do for this industry because of the federal ban. All of the money that this industry handles is considered the proceeds of illegal activity. Selling marijuana, maybe you're not going to be prosecuted, but all the money you make from that sale is still considered the proceeds of illegal activity. And that means any financial transaction involving those proceeds is defined as money laundering under federal law. The people who grow and sell the drug may say, we don't care. We're already flouting the Controlled Substances Act. We're already selling a drug that the federal government forbids. But if you try to go to a bank and get them to be complicit in that illegal activity, those prohibitions apply to banks as well, and tell them, hey, don't worry about it. The federal government isn't going to prosecute you. You can turn a blind eye to this violation and engage in money laundering with us. Much tougher to do that with financial institutions that are heavily regulated by the federal government, more conservative by and large than people who are growing and selling marijuana in the country right now. So that's one of the tensions, one of the hassles that companies in this industry continue to face is the difficulty of getting access to banking, because banks are so heavily regulated by the federal government. Even banks that are state chartered want to use financial systems that are controlled by the Federal Reserve. And any of those banks that do that technically are violating federal law. They're engaged in money laundering. There are some that are willing to do that. The Treasury Department, which is not the D.O.J., but the Treasury Department has its own guidance, which is still in effect, which says, as long as you're careful about this, as long as you screen your clients and make sure that they're complying with state law, we're not going to punish you, or we're unlikely to punish you. Some banks are willing to take that guidance at face value, willing to offer services, but many marijuana dispensaries and marijuana growers just can't get access to banking services, so they're left as cash-only businesses, which creates all sorts of headaches for them.
Well, but again, they might deal only in cash, but then they have the cash. They have to do something with it. So are states where the financial institutions are steering clear of these activities because of concerns, notwithstanding that Treasury Department guidance? Are they setting up alternative, banking institutions to deal with these funds?
They're trying to, but banking is one segment of the economy where it's almost impossible to escape the federal government. As I mentioned, one possibility that some states initially looked into was setting up a state chartered bank. So under federal banking law, you can either get a charter from the federal government or you can get a charter from the state government. And some people thought, well, if it's a state chartered institution, we're golden. We don't have to worry about these federal prohibitions. But that's not the case, because if that state chartered institution wants to use, for example, an electronic payment system, it's probably going to want to use the one that is operated by the National Federal Reserve. Right. And the Federal Reserve is a federal institution, obviously, and it has its own regulations about what sort of behavior its members should engage in, and those companies that are trying to use this electronic payment system. So there's really no one's been able to solve this particular barrier or move around this particular barrier. Instead, it's really the only way you can get banking services is to find a bank that's willing to flout federal law, willing to trust in that Treasury Department guidance that was issued. There are other obstacles federal law creates that the states have been able to cleverly work around, but this isn't one of them.
Mm-hmm. Well, can you give us an example of some of a barrier that they have more openly managed to work around with, if not this one?
Yes, so there's a great one that was really the reason why these medical marijuana laws took off in the first place. So there were actually medical marijuana laws adopted by the states back in the 1970s, including in places like Virginia. Virginia would say, if you get a prescription from your doctor to use marijuana to treat glaucoma, it's no longer an offense under state law to possess the drug. Mm-hmm. So Virginia, of all places, beat California to the punch by almost a couple decades. That was passed in the late 1970s. But those laws,
they must have been high. I don't know how that happened.
It's interesting that you see, and that's also the time. The 70s was a time when a lot of states were adopting decriminalization. Yeah. So this is before the Reagan sort of turn things around, and the Reagan administration, took a much harsher stance on lots of drugs, including marijuana. But what the states realized soon after that is that these laws are futile because physicians aren't going to be willing to write a prescription for marijuana. And the reason for that is if they do that, the Drug Enforcement Agency, this federal DEA, threatens to pull their authorization to write prescriptions for other drugs.
Yeah.
So if you're a physician, you get your license to practice medicine from the state, from a state board. But if you want to write a prescription for any controlled substance, which includes things like oxycodone, lots of things that physicians write prescriptions for, you have to get this license from the DEA. And the DEA at the time said, it violates our policies for you to be prescribing a drug that we consider to have no medical benefit, that's forbidden outright. So no physician was willing to participate, so these laws were just nice symbolic measures. But then California in 1996 came up with this idea of not requiring a prescription from a physician, but just a recommendation.
Yeah, that's
So
brilliant.
all California wanted at that time in 1996, this Compassionate Use Act, Prop 215, it said all you had to get if you're a patient who suffers from one of these conditions we've specified, you just need a physician to tell you, maybe write it down on a sheet of paper, maybe tell you orally that you might benefit from the use of marijuana. That's all that was required. And California thought this isn't a prescription, so it's not controlled by the DEA. Physicians who issue this recommendation to a patient, they can't be punished by the DEA, so they'll start to participate.
Right.
The DEA thought, well, this is a spurious distinction, recommendation, prescription, it's all the same. But the Ninth Circuit, a prominent federal court of appeals, agreed with California. It said a recommendation is not a prescription. Physicians have a First Amendment right to have this open and frank conversation with a patient. The DEA can't punish them simply for talking to their patient about the possible medical benefits of a drug. They can't tell the patient where to get it. You can't aid and abet some federal crime. But if you merely want to recommend marijuana to a patient, you've got a constitutional right to do that. And that's why. So the states were able to work around this barrier that the DEA had constructed on physician participation. Every state since California, every state today, all those 31 medical marijuana states and the District of Columbia, they only require a physician's recommendation to use marijuana rather than a prescription. So it's a good example of how the states were able to change their laws to get around a barrier that might be imposed by the federal government. They can do that for things like prescriptions and recommendations. Some barriers, though, are much harder to work around, like the banking one.
Right. That just seems like that's going to take a lot longer to get figured out. And maybe more and more states coming around so that the protections, like you mentioned, the Congress passes protection for the medical marijuana industry. Maybe those protections have to be codified. Maybe Congress has to take some action to strengthen that Treasury Department guidance so that banks, can engage it without the fear of, some federal crackdown.
And there are some proposals now on the table. Senator Warren, for example, Elizabeth Warren of Massachusetts, has proposed a Safe Banking Act that would change federal law and explicitly allow banks to deal with this particular industry. So there's a chance that Congress might pass things like that, either for the medical marijuana industry or maybe the broader industry as well, to deal with some of these problems that continue to face the industry.
I can't see them doing that in an election year, but maybe in an election year they could get to that. Well, Rob, this has been a fantastic overview, really, and analysis of how far we've come and some of the things we can look forward to on this issue as other states get involved and develop their economies and face all of this. And you're going to be raising a generation of lawyers to join what has become a really growing practice area, right? I mean, I'm amazed when I see the number of lawyers involved in the practice of law in this area, dealing with business, dealing with these banking issues and everything else. So it seems like it's only going to grow more so in the coming years, wouldn't you think?
Well, I agree. There are firms that have large numbers of attorneys that are dedicated just to this area of law. You also see sort of old school firms that have been around for a while, developing practice areas to deal with marijuana law. And in part, that's because you have so many states that are jumping on board, and you have, as I mentioned before, thousands of companies that are licensed to do business in those states, and they need lots of legal advice. You also have lots of third parties, though, that are affected by this area of law, whether or not they want to be. Companies like Walmart, for example. If you're a Walmart and you operate in a medical marijuana state, well, now you have to figure out, do I have to accommodate an employee's medical marijuana use off the job? Or can I maintain my same anti-marijuana, strict anti-marijuana drug policy that I have in other states like Idaho? So those are issues that lots of companies that have nothing to do with marijuana per se, but they really need legal advice on. And so I think that's why lots of firms are starting to enter this space, not just to serve the companies that are directly in the industry, but it's to serve all those other companies, the banks, for example, that are dealing with the industry, to help them out and guide them through, what is a very complicated area of law.
Incredible. It's reaching into every part of economic life, and that's inevitable. I hadn't even considered that. Well, Rob, thank you again. Thanks for being on Good Law, Bad Law and walking us through this fascinating conversation. Lots to look at and be interested in on this issue ahead. So really appreciate it, and thank you very much.
Thanks for having me, Aaron.